A unanimous suppressor decision just dropped, and the Department of Justice did the unthinkable. They didn't just lose a case, they surrendered. In a move that has sent shockwaves through the ATF, the DOJ has officially admitted that National Firearms Act regulations regarding suppressors are unconstitutional. This is not a maybe. This isn't a we might appeal. This is a total systematic reversal of a 90-year-old federal position. This changes everything for the 2.6 million suppressor owners currently in the NFA registry and every single person who ever plans on buying an NFA item going forward. If you own a suppressor, or if you've been waiting a year for a Form 4 to clear, hit that subscribe button right now, because what I'm about to show you, straight from the court filings, will blow your mind. The NFA as we know it is starting to dissolve in real time. To understand the magnitude of this, we have to look at the document that started the fire. On January 20th, 2026, Acting Associate Attorney General Benjamin Williams filed a 47-page confession of error in the case of United States versus Patterson. Now, in legal terms, a confession of error is the white flag. It's the government standing before a judge and saying, "We've been wrong for 9 decades. This wasn't some quiet memo buried on an internal server. This was a public court filing stating that the DOJ could no longer defend the suppressor provisions of the NFA under the Supreme Court's Bruin standard." Think about the sheer whiplash here. In September 2025, the same DOJ attorneys spent $400,000 in taxpayer money to write a 156-page appellate brief defending these exact regulations. In that brief, they argued that suppressors were dangerous and unusual, and that the $200 tax was a necessary public safety measure. Fast forward just a few months, and those same attorneys are now systematically dismantling every single argument they previously made. The reversal wasn't limited to one case either. DOJ attorneys filed notices of position change in 6 different circuit courts simultaneously, withdrawing opposition to suppressor challenges from Arizona to Maine. Cases that had been in litigation for 3 years suddenly saw government lawyers filing concessions. The DOJ finally conceded what we've known for years. Suppressors are in common use. With 2.6 million registered units, they can no longer be classified as unusual weapons. But they went further. They admitted the $200 tax stamp functions as a financial barrier that specifically prices poor Americans out of their constitutional rights. Think about that admission. The federal government just acknowledged they've been running an unconstitutional wealth test on a fundamental right for 90 years. But don't think for a second the DOJ found a conscience. This reversal was calculated. In the filing, the DOJ explicitly stated, "This confession applies only to suppressors and should not be read as abandoning defense of machine guns, short-barreled rifles, or destructive devices." The government was making a strategic retreat. They realized that if they lost on suppressors, the most sympathetic, hearing safety-focused category of the NFA, in a way that created a broad precedent, the whole NFA would fall. They tried to sacrifice the suppressor regulations to save the machine gun ban. They were trying to cut off a finger to save the arm. But as we're about to see, the Ninth Circuit panel refused to let them off that easy. Every revolution needs a face, and for this one, it's Michael Patterson. Now, Michael wasn't looking to become a constitutional hero or a test case plaintiff. He's a competitive shooting instructor out of Scottsdale, Arizona. He runs a firearms training academy where he works with both law enforcement and civilians. After 15 years of instruction, despite wearing double ear protection, Michael suffered permanent hearing damage. His hearing continued to degrade with every class he taught, every demonstration he ran. In March 2024, he decided he'd had enough. He purchased a silencer Co. Omega 9K suppressor for $650 specifically to protect what remained of his hearing. He followed every single hoop the ATF jumped him through. He paid the $200 tax stamp, he submitted his fingerprints and provided passport-style photographs. He notified his county sheriff, and then he waited. Michael waited 11 months and 17 days. During that time, his hearing continued to degrade. His Form 4 application sat in the ATF's National Firearms Act division while his constitutional right to protect his hearing was on hold. The Firearms Policy Coalition approached Michael with a radical idea. Don't just sue over the waiting period. Challenge the entire constitutional basis for the NFA suppressor framework. Michael agreed on one condition. The case had to seek relief for all suppressor owners, not just him. The complaint they filed in the District of Arizona didn't ask for reforms or minor adjustments. It didn't ask for a shorter wait time. It asked the court to declare the NFA's application to suppressors null and void. District Court Judge Sarah Henderson agreed. In September 2024, she issued a 73-page opinion finding that suppressors clearly meet the Bruin standard for constitutional protection, but that was just the beginning. The DOJ immediately appealed the case to the Ninth Circuit Court of Appeals. The place Second Amendment cases usually go to die, or so we thought. If you follow Second Amendment law, you know the Ninth Circuit Court of Appeals has a reputation that makes gun rights attorneys physically uncomfortable. Before this decision, the Ninth Circuit was where Second Amendment claims went to be buried. In fact, since the Supreme Court's Bruin decision in 2022, this circuit had ruled against gun owners in 23 consecutive cases. They upheld California's assault weapon ban, magazine capacity limits, ammunition background check requirements, and even a ban on firearm advertising visible from public streets. The three-judge panel assigned to Patterson made things look even bleaker. Judge Paul Watford had previously written opinions upholding California's 10-day waiting periods, even for people who already own guns. Judge Andrew Hurwitz authored the decision upholding Hawaii's ban on open carry. Judge Jacqueline Nguyen had never voted to strike down a single gun regulation in her entire career. Not one. Gun rights organizations like the Second Amendment Foundation and the Firearms Policy Coalition knew they were walking into an ambush. They had already allocated nearly $300,000 for the appeal, fully expecting to lose at this level and needing those resources for a Supreme Court petition. They were wargaming scenarios where the Ninth Circuit would issue an opinion so hostile it would create a bad precedent nationwide. The oral argument was scheduled for January 28, 2026. Everyone expected a disaster. But then the January 20th filing happened. The DOJ didn't just walk into the room, they walked out of it. By confessing error, the government essentially canceled the oral arguments. Instead of the disaster everyone expected, the panel was forced to look at a case where the defendant and the prosecutor now agreed the law was dead. And that led to an 89-page opinion that didn't just give Michael Patterson a win, it gave every gun owner in the West a revolution. What do you think forced the DOJ to reverse their position? Was it internal legal analysis, political pressure, or fear of losing even bigger at the Supreme Court? Drop your theory in the comments because this gets even more interesting. How did we get here? How did the most anti-gun court in the country find itself striking down federal law? It all comes down to the Bruin standard. Before 2022, courts used what they called interest balancing. They would look at your right, then look at the government's interest in public safety, and, surprise, surprise, the government's interest almost always won. But Justice Clarence Thomas ended that game. In the Supreme Court's 2022 decision in New York State Rifle and Pistol Association v. Bruin, he wrote that the Second Amendment is not a second-class right subject to interest balancing. Now, courts must use a text, history, and tradition test. First, does the Second Amendment's plain text cover the conduct? If yes, the government must prove the regulation is consistent with the nation's historical tradition of firearms regulation from the founding era. Think about what this means. The text question is easy. Suppressors are arms that help you bear a firearm safely. But the history question? That's where the NFA dies. This creates an impossible burden for the government. Think about it. Hiram Percy Maxim didn't even patent the first suppressor until 1902. How can the government point to a historical tradition of regulating suppressors from 1791 when the technology didn't exist for another century? The DOJ tried to argue that dangerous gunpowder storage laws from the 1700s were a good analogy. The court laughed that out of the room. A storage law for explosives is not the same as a $200 tax and a year-long wait for a metal tube that protects your hearing. The DOJ's own Office of Legal Counsel spent 7 months digging for a historical analog that could justify suppressor registration and taxation. They found absolutely nothing that survived scrutiny. They realized they were defending the indefensible. A $200 tax on a hearing protection device has no historical parallel to anything from the founding era. And that's exactly why the DOJ had to confess error rather than lose spectacularly at oral argument. Chief Judge Jacqueline Nguyen's 89-page opinion is being called a constitutional masterpiece by gun rights attorneys. It's already being cited as the most important Second Amendment decision since Heller. All 3 judges joined every section unanimously, making it binding precedent across 9 Western states. The opinion doesn't just knock over the NFA, it grinds it into dust using 3 independent pillars. Each pillar by itself is sufficient to strike down the suppressor provisions. Pillar 1 addresses the common use requirement from Heller. The government tried to argue that since only 2% of gun owners have suppressors, they are unusual. Judge Nguyen demolished this argument. She pointed out that when the Heller decision was written in 2008, there were only about 1.5 million AR-15s in the country, and the Supreme Court called those in common use. With 2.6 million suppressors today, the unusual argument is factually dead. If 1.5 million AR-15s qualified as common use in 2008, then 2.6 million suppressors certainly qualify now. Pillar 2 tackles the tax as a prior restraint. This is the one that should make every NFA owner cheer. The court looked at the $200 tax stamp. In 1934, $200 was the equivalent of about $4,600 today when adjusted for inflation. The average suppressor costs $600, meaning the tax is 8 times the value of the item being taxed. The court found that taxing a right at 800% of the item's actual value is an unconstitutional prior restraint. You wouldn't pay an 800% tax to vote or to exercise free speech, and the court ruled you can't be forced to pay it to protect your hearing while exercising the Second Amendment. The court wrote that requiring citizens to pay $4,600 in today's dollars to exercise their Second Amendment rights is no different than requiring them to pay $4,600 to exercise their First Amendment rights. Pillar 3 addresses the waiting period as a de facto ban. The court found that a 9 to 12-month delay in exercising a constitutional right, with no maximum time limit and no recourse if the government simply sits on your paperwork, constitutes a complete ban on the right. Patterson waited nearly a year for approval after already passing a background check that took 15 minutes. The government could offer no explanation for why a background check that takes 15 minutes when buying a handgun should take 11 months when buying a suppressor. They noted that Patterson's actual background check took 15 minutes, but the NFA process took 350,000 minutes. That, the court said, is a violation of the right to keep and bear arms, not wait and eventually bear arms. Judge Nguyen didn't just strike down the law and walk away, leaving a vacuum of chaos. This is critical to understand. The Patterson decision includes a highly detailed 90-day implementation order. This is the roadmap for how the ATF must dismantle its own suppressor bureaucracy without compromising the existing background check system. Here is what happens immediately. As of January 23, 2026, the ATF has been ordered to cease all collection of the $200 tax stamp for new suppressor purchases. If you walk into a gun store today, you pay only for the suppressor itself. You still undergo a standard NICS background check, the exact same one you do for a handgun, but the days of fingerprints, passport photos, ATF Form 4s, and Chief Law Enforcement Officer notifications for suppressors are over, done, finished. But what about the people already in the system? The court was incredibly specific here. For the roughly 347,000 people with pending Form 4 applications submitted before January 23rd, the ATF has been given 14 days to auto-approve those applications, provided the applicant passes a standard NICS recheck. That means if you submitted your Form 4 before January 23rd and you're still waiting, the ATF has until February 6th to approve your application or provide a specific legal reason for denial. No more waiting 11 months like Michael Patterson did. And here's the kicker that nobody saw coming. The court ordered the ATF to refund all $200 tax stamp payments for applications submitted after January 1, 2024. We are talking about an estimated $69.4 million being returned to American gun owners. For the first time in history, the government is being forced to pay back the prior restraint it unconstitutionally collected. Within 90 days, the NFA registry for suppressors is legally required to become obsolete. Most significantly, the court ordered that all persons currently in lawful possession of any firearm are deemed lawful possessors of suppressors without registration. Do you think this implementation timeline is realistic, or is the ATF going to fight this and cause chaos? Let me know in the comments what you think happens when April 23rd arrives, because I have my own theories about bureaucratic resistance. If you think this ends with suppressors, you haven't read the dicta. Judge Nguyen included a 20-page section of legal guidance, statements not strictly necessary for the suppressor ruling, but intended to guide future cases. In this section, she systematically applies the Bruin analysis to short-barreled rifles and shotguns. The implications are devastating for what remains of the NFA. She pointed out that the government's justification for regulating SBRs, that they are unusually concealable, is logically inconsistent in a world where millions of Americans legally carry concealed handguns every day after Bruin struck down May issue permitting. Furthermore, the court noted there are now 4.2 million AR-15 pistols and braced firearms in civilian hands. These are essentially SBRs by a different name, and they are clearly in common use for lawful purposes, including home defense. Judge Nguyen wrote that she could find no principled distinction between an AR-15 pistol with a 13-inch barrel and an AR-15 rifle with a 13-inch barrel, except that one requires a $200 tax and one doesn't. That arbitrary line just became legally indefensible. Within 18 hours of the Patterson decision, 3 separate lawsuits were filed challenging the SBR provisions of the NFA, all in the Ninth Circuit, to take advantage of binding precedent. Because Patterson is now binding precedent in the circuit, legal experts are giving these new cases a 95% probability of success. The barrel length restriction is the next domino to fall. Now, a word of caution for those of you in banned states. This is a federal decision striking down federal law. However, 8 states, including California, New York, New Jersey, Illinois, Massachusetts, Rhode Island, Delaware, and Hawaii, have their own independent suppressor bans written into state criminal codes. Even though the NFA registry is dead, a suppressor could still be a felony under California Penal Code 33410 or New York Penal Law 265.10. These state laws were written to mirror federal NFA restrictions, but they remain on the books as independent criminal statutes. But the clock is ticking for those states too. Because the Second Amendment is incorporated against the states via the 14th Amendment, these state bans must now face the same text, history, and tradition test that just killed the federal NFA provisions. The legal pathway is clear. If the federal NFA suppressor provisions violate the Second Amendment, then identical state provisions also violate the Second Amendment. California already has a pending suppressor ban challenge that was stayed waiting for developments in federal NFA litigation. That case will now move forward with Patterson as binding precedent. Gun rights attorneys estimate these state-level bans will fall within the next 12 months. Finally, we have to address the third rail of the Second Amendment, machine guns. The 1986 Hughes Amendment created a closed registry, effectively banning any machine gun manufactured after May 19, 1986. This artificial scarcity has driven the price of a $600 rifle to $30,000 or more for the approximately 630,000 transferable machine guns that exist. The Patterson decision creates a massive opening here. The constitutional analysis for machine guns is harder than suppressors because of United States v. Miller from 1939, which stated that the Second Amendment protects weapons with a reasonable relationship to militia use. Machine guns are clearly militia weapons. They're standard issue for every military force on Earth. But Miller also stated that weapons must be in common use, and the Hughes Amendment has artificially prevented machine guns from being in common use by freezing the supply for 40 years. Here's where Patterson creates the opening. The court held that the government cannot argue an item is unusual if the government's own regulations are what prevented it from becoming common. This strikes at the very heart of the Hughes Amendment. Before 1986, machine gun registrations were growing at 15,000 to 20,000 per year. If the government hadn't frozen the registry, there would be over 1.2 million registered machine guns today, easily meeting the common use threshold established in Heller and reaffirmed in Patterson. Second, Patterson holds that registration and taxation requirements are unconstitutional prior restraints. The Hughes Amendment doesn't just tax or register machine guns, it bans them entirely for civilians. If a $200 tax and registration violates the Second Amendment, an absolute ban certainly does. The Firearms Policy Coalition has already confirmed they are recruiting plaintiffs for a Hughes Amendment challenge in the Fifth Circuit, the most gun-friendly appellate court. If the logic of Patterson holds that registration and taxation are unconstitutional prior restraints, then an absolute ban is certainly on the chopping block. The NFA is crumbling in real time. We are witnessing the most significant restoration of Second Amendment rights in our generation, but make no mistake, the ATF will not go quietly. The ATF has 90 days to implement this decision. That's 90 days for bureaucrats who've spent their entire careers enforcing the NFA to figure out how to dismantle it. I want to hear from you. Do you think the ATF will actually comply with this 90-day rollout, or are they going to manufacture technical glitches to cause chaos? And here's the ultimate question. Do you think the Hughes Amendment machine gun ban will survive constitutional scrutiny after Patterson, or is the NFA completely finished? Drop your theory in the comments below because this is the most consequential legal battle of our time. If you want to stay ahead of the curve as the SBR and machine gun cases move through the courts, hit that subscribe button and turn on notifications. Share this video with every gun owner you know. The NFA is on the ropes. Let's keep the pressure on.